Hello, my name is Adam Johnson, and I am an attorney with the Denver Regional Office of the Federal Labor Relations Authority, or the FLRA, and I'm here to speak to you today about unfair labor practices, or ULPs, committed by unions. Now, before I get into the presentation, I want to explain two terms that you're going to be hearing me using very frequently. And the first is you'll hear me refer to the authority. And what the authority is it's a component of the FLRA that, amongst other things, essentially is our Supreme Court. They're the highest level of review. So if you hear me talking about a decision or a case and I say the authority decided, all that means is that the case made its way all the way up to the top of our agency, and the authority then issued a decision that's binding on the rest of our agency. The second term you'll hear me use a lot is the statute. And when I say the statute, I'm referring to the Federal Service Labor Management Relations Statute, which is a piece of legislation that was passed in 1978 by Congress, and it created the FLRA as well as all of the laws that govern the collective bargaining relationship between unions and management in the federal government. And it also created all of the laws that define what sorts of behaviors constitute unfair labor practices. So before we get into specific types of ULPs, let's talk about something that the statute does when it comes to defining unions. The statute gives unions the right to be the exclusive representative in the federal workplace. And that means exactly what it sounds like. It means that the union is the only or the exclusive representative when it comes to exercising certain powers under the statute or pursuing certain types of actions under the statute, such as grievances and ULPs. And this is significant because it means that employees only have two options. If they want to file a grievance or they want to file an unfair labor practice, they can do two things. They can either represent themselves or they can be represented by the exclusive representative, aka the union. They can't hire their own attorney. They can't appoint another employee to represent them. They have to use the exclusive representative. So what that means is that unions need to take very seriously their representative responsibilities under the statute because employees don't have any other option for representation. And as a result, we take very seriously claims that unions are not abiding by those duties. Okay, so when I think about union ULPs, I like to divide them into two categories. The first is ULPs against federal agencies in which the union has violated a duty that it owes to management. The second category is ULPs against individual employees in which the union has violated a duty that it owes to the actual individuals who make up the workforce. So let's start with ULPs involving federal agencies. And the most common that we see is bad faith bargaining. 5 U.S.C. section 7116B5 makes it an unfair labor practice for a union to refuse to consult or negotiate in good faith with an agency as required by this chapter. And management has the exact same duty towards the union. They're also required to bargain in good faith. And all this means, all that Congress was trying to accomplish when they included this provision in the statute, was they were trying to make sure that when unions and management sit down at the bargaining table, they are playing fair, they're being courteous to each other, they're not wasting each other's time, and they are approaching the negotiating table with a sincere resolve to attempt to find a solution. So let's say a federal agency believes that a union has engaged in bad faith bargaining, and they file an unfair labor practice charge with us. How do we decide if that's the case? Well, we look at three factors. The first is whether the union approached negotiations with a sincere resolve to reach an agreement. The second is whether the union is meeting at reasonable times and convenient places as frequently as needed. And the third is whether the union is avoiding unnecessary delays. So like I said, we're just trying to ensure that people are being good bargaining partners, that they're not jerking each other around, and that they are making a sincere effort to come to the table and try to solve the problem. But in the real world, bad faith bargaining doesn't always look as simple as the union skipping previously scheduled bargaining sessions or blowing off management's attempts to try to sit down at the table or causing unnecessary delays. Sometimes it's a little bit more nuanced than that. So let's look at a couple examples. This first case on the slide right here, AFGE Local 1815, what happened there was a union sat down with an agency to try to negotiate an entirely new collective bargaining agreement. And they went through each provision of the agreement one by one. And both parties signed off on every single agreement. They ratified every agreement, but when it came time to ratify the collective bargaining agreement in its entirety, the union refused to do so. In fact, they withheld their signature in an attempt to extract more concessions from management. And management was understandably upset because the union had already agreed to every single individual provision. So they filed a ULP with us accusing the union of bargaining in bad faith. And the authority found that this was indeed an example of bargaining in bad faith because the fact that the union had agreed to every single provision but then refused to ratify the whole thing was evidence that they had never actually approached the negotiations with a sincere resolve to reach an agreement. Now, another common example of a union violating the duty to bargain in good faith involves the repudiation of settlement agreements. So if a union brings a grievance or an unfair labor practice, and then they settle that case with management, and then immediately thereafter they turn around and they violate that settlement agreement, that means that they're repudiating the agreement, and we treat that as an instance of bargaining in bad faith. In this second case on the slide, AFGE Local 1923, the agency in that case, they proposed to remove an employee, meaning they were going to fire the employee. And the union said, if you fire this employee, we are going to challenge that action with a grievance. The agency said, well, how about this? Why don't we reduce the proposed punishment to a one-day suspension in exchange for a promise from you that you won't file a grievance? The union said, okay, great, and they signed off on the settlement agreement. Almost immediately after they signed the agreement, they turned around and they filed a grievance challenging the one-day suspension. So the agency filed a ULP with us, and the authority agreed that this was evidence of bad faith bargaining because the fact that the union violated the agreement almost immediately after it had signed it was evidence that the union never intended to be bound by the agreement in the first place. All right, next let's talk about strikes and work stoppages. 5 U.S.C. Section 7116B7 makes it an unfair labor practice for a union to call or participate in a strike, work stoppage, or slowdown, or picketing of an agency in a labor management dispute if such picketing interferes with an agency's operations, or to condone any such activity by failing to take action to prevent or stop such activity. So this is pretty strong language. Not only are unions prohibited from engaging in strikes or trying to organize strikes or work stoppages, but they're actually supposed to take affirmative action to try to stop such activity. And this is reflective of the fact that Congress just did not want strikes to be part of the equation at all when it came to the federal workplace. Now, examples of this conduct are exceedingly rare. In fact, strikes are almost extinct in the federal government. There hasn't been one for a very long time. There are two examples on the slide. Both are from the early 1980s, and that's not a coincidence. That's just because there haven't really been any examples in recent years. But the first example was actually fairly famous as far as these types of things go. In 1981, many of the air traffic controllers at the Federal Aviation Administration went on strike. And the strike was called and organized by their union, which was the Professional Air Traffic Controllers Organization, or PATCO. And the FAA filed an unfair labor practice with us, alleging that the union was guilty of violating Section 7116B7 by organizing this strike. The authority agreed, and as a remedy for the FAA, they decertified PATCO, meaning that PATCO ceased to exist after that case. Now, that's an extremely harsh remedy, but it shows you just how seriously the authority takes strikes. Now, work stoppages or slowdowns are not always as dramatic as situations where people pick everything up and they walk out of the workplace and they refuse to come back until management meets their demands. There can also be things called work slowdowns. In the second example on the slide, in the Social Security office in Baltimore, Maryland, About 60 employees, at the encouragement and with the participation of their union leaders, they all stopped what they were doing in unison, and they marched to the office of the director in order to air their grievances about what they viewed as shoddy working conditions. The Social Security Administration filed a case with us saying that this was a work stoppage that was encouraged by the union, and the authority agreed. And what the authority said was, we have proper procedures in place to address these types of things. If you think that your work conditions are bad, go ahead and file a grievance. It's not acceptable to coordinate an activity in which everybody on the workplace stops at the same time, marches down to management, and airs their grievances orally. That's just not how that works. That constitutes a work stoppage. All right, just a couple more union ULPs involving management before we move to ULPs involving individuals. And this next one involves proceedings before the Federal Service Impasse Panel, or FSIP, or FSIP as we call it here at the FLRA. And FSIP is a component of our agency that helps parties resolve bargaining disputes. If a union and an agency are bargaining a new contract and there's a subject matter where they simply cannot come to an agreement or they've reached an impasse, they can take their case before FSIP and they can say, hey, we need your help, and FSIP will issue a decision ordering the parties to adopt certain language into their contract that resolves that specific dispute. So 5 U.S.C. section 7116B6 makes it an unfair labor practice for a union to refuse to cooperate in the procedures that govern FSIP proceedings, and it also makes it an unfair labor practice for a union to refuse to abide by a decision issued by FSIP. All right, last one, and that is that it's a ULP to engage in internal union business on duty time, and the most common examples of internal union business are soliciting union membership, holding elections of union officers, and collecting union dues. So if you are a union official and you plan on organizing any of these activities, just make sure you don't perform them during duty time, or else you could be found in violation of the statute. All right, now let's move on to union ULPs involving individual employees. And the first thing I want to talk about is something called the duty of fair representation. The union has an obligation as the exclusive representative to represent the interests of all employees in the unit that it represents without discrimination and without regard to union membership. So what that means is that even if you are not a dues-paying member of the union, you are entitled to the same type of representation, the same effective and enthusiastic representation as someone who actually does pay dues to the union, so long as you are in the bargaining unit. And if anybody is watching this who doesn't know what the term bargaining unit means, the bargaining unit is the universe of employees who are eligible to join the union. There are certain categories of employees who, by law, are not allowed to be in the bargaining unit. The most obvious example is management officials, but some other examples include people whose job functions touch on national security issues, or people who are involved in personnel and hiring decisions. But anybody who is not specifically excluded under the statute from being in the bargaining unit is in the bargaining unit. Now, again, the difference, the distinction between somebody in the bargaining unit and somebody in the union is that a union member pays dues to the union. That's the only difference. And the union is obligated to equally represent all employees in the bargaining unit, even if some of those employees don't pay dues to the union. So when does the duty of fair representation apply? It doesn't apply always. It applies when the union is acting in its capacity as the exclusive representative. So in other words, it applies anytime the union is acting pursuant to the powers that it was granted by the statute. The most common examples of that are filing grievances and filing ULPs. A union is obligated to pursue grievances and ULPs for non-members the exact same way that they would for members. Also, if a union is negotiating a new contract, it can't try to carve out goodies for union members that non-members don't have access to. That's also a circumstance in which the union has to represent everyone in the bargaining unit equally. Another circumstance where we see this sometimes is when unions charge non-members more for union-administered insurance plans than they do members. A union can't charge a non-member more than it does its members for union-administered insurance plans. A couple other examples. Let's say that the union files a grievance on behalf of a huge number of bargaining unit employees, and they receive a monetary award in response to that grievance. So I'll just use this exact example that's on the slide, this Loring Air Force Base case. The union filed a grievance on behalf of a large number of employees because lots of people were exposed to asbestos on the workplace. And they received a settlement for, it was a large amount, I think it was $125,000, but it was a big chunk of change. And when it came time to distribute that money to the grievance, to the people who were entitled to damages, the union did it in a way that prioritized its own members over non-members. So some of those non-members filed a case with us alleging that the duty of fair representation had been violated, and the authority agreed. Another example is in some collective bargaining agreements, unions are granted the power to establish certain conditions of employment. And if they establish those conditions of employment in a way that prioritize members over non-members, that's also a violation of the duty of fair representation. In this NACTA case that's on the slide, the union was in charge under the collective bargaining agreement of determining how seniority would be calculated. And they calculated seniority in a way that gave seniority to dues-paying members over non-members, regardless of whether or not those members had worked more days and actually were more senior. The authority found that this, of course, was a violation of the duty of fair representation. Now, I just said that the duty doesn't apply all the time. And the most common circumstances where the duty does not apply is when a union is acting in a venue outside of the Federal Labor Relations Authority that is not governed by the statute. And the two most common examples of that are when employees have cases before the Merit Systems Protection Board, or the MSPB, and the Equal Employment Opportunity Commission, or the EEOC. So the MSPB hears challenges to adverse actions, and an adverse action is a suspension of 14 days or more, a removal, a demotion, or a reduction in pay. So let's say that your union generally represents its members if they have a case before the MSPB. You're not a member of the union, but you've just been suspended for 20 days. You want to take your case to the MSPB. And you approach the union and you say, I want your assistance with this. Because this is occurring in a venue outside of the FLRA, the union is free to say to you, we're not going to represent you because you're not in the union, or alternatively, we will only represent you if you join the union and you start paying dues. The union is free to say that in this circumstance. Now, remember I said the duty does not apply when the union is not acting as the exclusive representative. So it's only the exclusive representative when it's acting to its powers under the statute. At the MSPB, it's no longer the exclusive representative. An employee before the MSPB would be free to hire his or her own attorney or to appoint any other individual they felt like to represent them. Same thing before the EEOC, which is the agency that hears challenges or hears accusations of discrimination at the workplace based on race, age, gender, etc. If you have a case before them and you approach your union for help, but you're not a member, they're free to tell you that they're not obligated to represent you. Another important example where the duty does not apply is during the proposal stage of discipline. Let's say that your agency is investigating whether or not you are guilty of some sort of misconduct, and they hold an internal hearing where they are trying to figure out whether or not to propose to discipline you. If you're not a member of the union, you would not necessarily be entitled to representation during that process. Now, if the discipline is announced and you choose to challenge it through a grievance, you would then be entitled to representation from your union because the union is then the exclusive representative. And the provisions that the union breaches when it violates the duty of fair representation are 5 U.S.C. section 7116 B1 and 8. Okay, so let's say that an employee files an unfair labor practice with us and they're alleging that their union is guilty of violating the duty of fair representation. What is the framework through which we will analyze that claim? Well, the first thing we do is we ask whether or not that person is a dues-paying member of the union. If she is not a member, then the FLRA applies a different test than it would if the person was a member. And the FLRA is attempting to assess whether the union discriminated against this person because she is not a member of the union. The name of that test is called the Letterkenny test. It's called that because it came out of a case that arose from the Letterkenny Army Depot, which is an Army facility in Pennsylvania. And this test has 3 prongs. If you file a case alleging that your union violated the duty of fair representation and you are not a dues-paying member, you have to show 3 things. The first is that you were engaged in protected activity. And let me stop for a second here and explain what protected activity is. There are certain things under the statute, certain types of activity that are protected. And that includes the right to form, join, or assist a union, or most importantly in this case, to refrain from any such activity. So if you are not in a union, you are exercising your right to refrain from joining that union. So back to the Letterkenny test. The first question is whether the employee was engaged in protected activity. If you're not in the union, you are automatically engaged in protected activity because you are exercising your right to not participate in the union. The second question is whether a discriminatory action was taken against you. So let's say, hypothetically speaking, you approach your union wanting to file a grievance, and the union refuses to file that grievance on your behalf. That could be a discriminatory activity. The third question is whether the employee's protected activity, in this case refusing to be, or not being part of the union, was a motivating factor in the union's disparate treatment of that employee. And if you can show all 3 of these factors, what you've done is you've established something called a prima facie case of discrimination. And prima facie is just a fancy way of saying that it's taken as true until proven otherwise. So it shifts the burden of proof to the union to show that they had a legitimate reason for taking the action that they took. And the union can rebut this prima facie case by saying, hey, we had actually a good reason to take the action that we took against this employee. So to give you an example, there was a case where an employee was fired and he wanted to challenge his firing through a grievance. So he approached the union and the union filed a grievance on his behalf. And he had ceased paying dues to the union because he got fired. So he wasn't getting a paycheck. There were no dues being withdrawn from his paycheck. And there was a dispute between him and the union as to whether or not he needed to be paying his dues. Now, eventually, the union decided to drop his grievance, and he filed a ULP with us saying, they're discriminating against me because I stopped paying my dues, and I don't have to pay my dues. It's protected activity for me to refrain from joining or assisting a union. However, the union was able to prove that they had a legitimate reason for dropping his grievance. They showed evidence that he was an unreliable witness and that they couldn't reliably put him on the stand if the grievance went to arbitration. And they showed that the grievance had almost no chance of succeeding if they were to see it through. So they were able to establish that they had a legitimate reason for taking the action that they took, and they were able to rebut his prima facie case of discrimination. All right, now let's say you're an employee. You're an employee and you file a case with us, and you're actually a dues-paying member of the union, and you think that the union has violated its duty of fair representation to you. Can you still win a ULP? And the answer is yes, but it's harder to do. The union's action, whatever they did, it has to amount to more than negligence or ineptitude. It has to have been arbitrary or in bad faith, and it must have resulted in disparate or discriminatory treatment of an employee. So what does this look like in the real world? Well, let me give you a couple examples. In this first case on the slide, AFGE Local 3529, there was a union president who had just assumed that position. He didn't have any experience. He didn't really know what he was doing. Somebody approached him and asked him to file a grievance. He missed the deadline. He just forgot. He made a rookie mistake. He didn't mean to, but he just was in over his head. So that employee, who was a dues-paying member of the union, filed a case with the FLRA saying that the union had violated its duty of fair representation. And the authority said, in this case, it was not a violation because the union's actions were simply negligent. It wasn't in bad faith. It wasn't so arbitrary as to be completely unreasonable. It was just a mistake. And I've explained this standard to people before, and they're frustrated by it. They say it's really unfortunate that we don't have some sort of remedy if the union is doing a poor job of representing us and it's not up to the task and it constantly is dropping the ball. And that's not 100% true. You do have a remedy, and that is you can vote for new leadership in the next union election. And that's frustrating that that's the only remedy, but that is what the law allows for. But that doesn't mean that a union can get away with anything. In this second case on the slide, somebody filed a grievance, and he was doing a good job of following up with the union to make sure that his grievance was being processed in a timely fashion. And the union lied to him, and they said that the grievance had been filed when it hadn't. And when he continued to try to follow up to see where his grievance was, they either misled him about its status or they completely ignored his attempts to contact them. The authority said that this arose to more than negligence or accident. In this case, the union was found to have deliberately and unjustifiably failed to file a grievance. So even though it is difficult for a dues-paying member to prove a claim of duty of fair representation, it's not impossible. Now, I also said that a union can violate its duty of fair representation when it acts in bad faith. So how does the authority define bad faith? The first thing we do is we conduct a subjective inquiry into what the union's motives were to see if the union was motivated by any improper factors. And the number one factor that we will look for is whether the union was motivated by personal animosity or a personal vendetta to any employee. A couple examples of how this has manifested itself in the workplace. In this first NACTA case on the slide, and remember I discussed the NACTA case earlier involving the calculation of seniority. Same issue here, the calculation of seniority, same union, different circumstances though. What happened here was that NACTA calculated seniority in such a way that if anyone left the bargaining unit to join management, even if it was for a short detail, they lost all of the seniority that they had accumulated up to that point. And the employees who filed the ULP were able to show that the union was motivated by a desire to punish those who had joined management and also motivated by a desire to discourage future employees from joining management. The authority found that this amounted to bad faith in violation of the duty of fair representation because your actions as a union cannot be motivated by personal animosity towards employees. In another example, an employee had supported a rival union in the past, which is fine. You're allowed to support rival unions if there's an election or anything like that. Fast forward a little bit, he wanted to file a grievance. He approached the union. The union refused to take his grievance. There was evidence to show that the reason the unions refused to take his grievance was because they still harbored a personal vendetta against him for supporting that rival union in the past. Again, this is being motivated by an inappropriate factor. You can't refuse to represent somebody because you have some sort of beef with them from the past. Final example on the slide. There was an employee who had some sort of long-standing dispute with some members of the union. It was a personal dispute, and the union won a grievance on behalf of lots and lots of employees, and they were all entitled to back pay. The union removed this person from the list of employees who were entitled to back pay in order to punish him for whatever sort of dispute they had in the past. Clear example of acting in bad faith, clear violation of the duty of fair representation. Okay, the next ULP I want to talk about is something called unlawful interference. And when I say interference, I'm talking about a scenario where a union is interfering with an employee's exercise of a protected right. 5 U.S.C. Section 7116B1 makes it an unfair labor practice for a union to interfere with, restrain, or coerce any employee in the exercise by the employee of any right under the statute. Now remember, earlier I discussed protected activity, right? So protected activity is defined by 5 U.S.C. Section 7102. And even though I already touched on this, here's the full provision. It says that each employee shall have the right to form, join, or assist any labor organization or to refrain from any such activity freely and without fear of penalty or reprisal, and each employee shall be protected in the exercise of such right. So in this case, involving union interference, the protected activity is usually somebody choosing to refrain from joining or assisting a union. So what does this look like in the real world? Well, it tends to manifest itself differently against non-members than it does against members. When we're dealing with non-members, it often manifests itself in the form of the union dangling some sort of benefit in front of non-members that non-members are entitled to under the duty of fair representation, and then suggesting, hey, maybe if you join the union, you'll have better access to this benefit. That's an example of trying to coerce somebody during the exercise of their protected right to not join the union. So to give you an example, this third case down on the slide, this AFGE Local 987 case, there were overtime issues that were plaguing the entire workforce. And the union wrote an article in its newsletter about these overtime issues. And in the article, they suggested that employees who wanted to file grievances challenging the overtime issues would get better or quicker representation if they joined the union. This is impermissible because those employees, by virtue of being in the bargaining unit, they're entitled to prompt and effective representation that's equal to representation of dues-paying members simply by virtue of being in the bargaining unit. They don't have to join the union to have access to that representation. And by suggesting that they would have better representation by joining the union, the authority found that this was an impermissible attempt to coerce people into joining the union in violation of their right to refrain from joining the union. A similar example, this second case on the slide, AFGE Local 2437, there was a new employee orientation, and unions are frequently granted a block of time at new employee orientations in order to give a presentation, just talk about what the union does, how they can assist employees, what the benefits are of joining, etc. So the union was presenting at a new employee orientation, and they suggested that people who joined the union would have a higher quality of representation in grievances and ULPs than people who didn't join the union. So very similar to the previous example, the authority found that this was an impermissible attempt to coerce people into joining the union. They're entitled to the same grievance and ULP representation as dues-paying members are. And by suggesting that they don't have that access to representation is an attempt to coerce them in the exercise of their right to not join the union. Okay. A union can also violate 7116B1 towards its members, towards its dues-paying members. And this usually happens in a slightly different manner. This is usually when a union member is engaged in some sort of protected activity that the union just doesn't like. So in this first case on the slide, this NTEU Chapter 53 case, a union steward testified at an arbitration hearing, and the union did not like what he had to say, and so the union stripped him of his stewardship. Testifying at an arbitration hearing is protected activity, and retaliating against one of your members for engaging in that protected activity is a violation of Section 7116B1. Another way to illustrate this is in this second case on the slide, AFGE Local 1857. A union steward discovered by virtue of the fact that she was a member of union leadership that the union was refusing to take an employee's grievance because that employee was not a dues-paying member. So the steward approached that employee and encouraged her to file an unfair labor practice against the union for violating its duty of fair representation. When the union discovered that its own steward had encouraged an employee to file a ULP, they rung her up on internal disciplinary charges, and they charged her with conduct unbecoming of a union member, and they stripped her of her title as union steward. She filed a ULP saying, hey, I'm allowed to encourage another employee to file a ULP. And the authority agreed. The authority said that that was a protected activity, and to punish her for engaging in that protected activity unlawfully interfered with her exercise of that right. All right, this final example on the slide, this New Jersey National Guard case, is a little different because it involves somebody trying to leave the union. An employee wanted to leave the union, and a union official started harassing him about this and bullying him, telling him that he wasn't man enough to stand up for his rights as an employee, and he sort of took advantage of this person's ignorance of the law by threatening to file some sort of legal action against him. And he said that if the guy remained in the union, then he would drop the legal action. The employee filed an unfair labor practice. The authority said that you cannot try to coerce somebody if they are trying to drop out of the union. People are allowed to drop out of the union. That's protected. And by threatening people or attempting to intimidate people into staying in the union is a violation of 7116B1. All right, we're approaching the end here, just 5 or 10 more minutes. Bear with me. The next ULP I want to discuss is 5 U.S.C. Section 7116B2. This makes it an unfair labor practice for unions to cause or attempt to cause an agency to discriminate against any employee for engaging in protected activity. So basically, unions cannot conspire with management to try to get people disciplined for engaging in protected activity, or a union, if somebody does something that's protected that a union doesn't like, a union can't then go and run to management and try to stir up disciplinary charges against them. So there was a case where an employee was very dissatisfied with union leadership, and he wrote out a letter and he distributed it to many of his coworkers in which he was criticizing the specific issues that he had with union leadership. Now, criticizing your union leaders is protected activity. You're allowed to speak out against any union. But when the union caught wind of this, they embarked on a campaign to try to get him disciplined with management. They went to management and they tried to get him accused of misusing company property by using the photocopier to make copies of that letter, and misusing duty time by trying to, or by engaging in this conduct while he was at work. And it was clear that the union didn't care about using the copier. They didn't care about him, whether or not he was using or misusing his duty time. They clearly wanted him to be disciplined because he had criticized them. The authority found that this was a violation of 7116B2 because he was engaged in protected activity, and the union tried to get him disciplined as a result. In another case, this case that's on the slide, AFGE Local 2258, 2 employees were having a conversation at work, just a regular conversation in the middle of some cubicles. One of those employees was the vice president of the union. The other employee, who was not the vice president, was being critical of the vice president's union leadership. Right after the conversation ended, the vice president wrote an email to management accusing this other employee of having accosted her in a rude and aggressive fashion and engaging in conduct unbecoming of an employee, and insisting that she be disciplined. But there were several witnesses who were nearby during this conversation, and they all said that there was nothing unusual about it. Nobody raised their voices. Nobody was acting rudely. And so there was enough evidence to show that the union vice president only sent that email to management because she was upset that the employee had been criticizing her union leadership. Classic example of a violation of B2. The employee was engaged in protected activity, that is criticizing union leadership. The union leader's response was to try and get her disciplined by management. All right, let's talk about when unions can actually remove somebody from membership. And remember that being kicked out of the union doesn't mean that you're kicked out of the bargaining unit. You're still in the bargaining unit. You're still entitled to representation from your union, but if you are kicked out of the union, you might be banned from attending union meetings, or you might be banned from running for union office, amongst other things. But 5 U.S.C. Section 7116C says that a union can't deny membership to any employee except for failure to meet reasonable occupational standards uniformly required for admission or to tender dues uniformly required as a condition of acquiring and retaining membership. So basically, if the union has internal rules that they've established in their constitution, they're allowed to enforce those. Also, if somebody stops paying their dues, the union is allowed to kick them out. But they can't kick somebody out just for any reason that they see fit. However, Section 7116C does specify that it does not preclude any labor organization from enforcing discipline in accordance with procedures under its constitution or bylaws to the extent consistent with the provisions of this chapter. So if an employee gets kicked out of their union, they file a ULP with us alleging that management has violated 5 U.S.C. Section 7116C. We will look to see whether the conduct in question wholly involves union affairs. And if it wholly involves union affairs, then we decline to exercise jurisdiction because that's none of our business. So hypothetically speaking, let's say that a member of the union is misappropriating union funds. Let's say they get sent to a training conference across the country, and it turns out that they're using the union credit card for all sorts of inappropriate expenses. They're going out for meals and et cetera. If they get kicked out of the union, we would say that's wholly union affairs. That doesn't involve us. That's none of our business. The union's free to remove you. However, if somebody gets kicked out of the union for exercising protected activity, that's when it spills out of the confines of internal union affairs and into the realm that we were created to police. So let's say that somebody files a ULP against the union, or they criticize union leadership, and they get kicked out as a result. That would be a clear violation of Section 7116C because they're allowed to engage in protected activity, and by kicking them out, the union has violated that provision. Now, there's one exception, and that's where that's where an employee brings a decertification petition against the union. And a decertification petition means that you're trying to decertify the union, trying to make it cease existing. The authority has found that it's okay to kick an employee out if they try to bring a decertification petition against the union because that represents an attack on the very existence of the union. All right, just a couple more and then we'll be finished. The next one is 5 U.S.C. Section 7116B3, which makes it an unfair labor practice for unions to discipline its members for performing their work duties or to discipline them in a manner designed to prevent them from doing their duties. These cases are incredibly rare, but let's say that a union president calls up one of his stewards and says, hey, I need your help on a grievance. The steward is swamped at work doing his regular duties, and he says, I'm just too busy at the moment, I really can't. And then the union disciplines that person for doing that. That would be a violation of this provision. And the reason that Congress created this is they wanted to make sure that union work was not overly interfering with the regular mission of the agency. Next, under 5 U.S.C. Section 7116B4, it's an unfair labor practice for a union to discriminate against employees on the basis of race, color, creed, sex, age, political affiliation, etc. These cases are so rare that I'm not even aware of a single example that's made its way to the authority, which is good. But just know that if you are a member of a union and you feel as though they're discriminating against you due to one of these factors, you do have an avenue of recourse. You can file an unfair labor practice with us under this provision. All right, last one. Unions can't come up with dues revocation procedures that are inherently coercive. And all that means is that unions can't make it too difficult for their members to withdraw from the union. In this Portsmouth Naval Shipyard case, the union forced employees who wanted to withdraw from the union were forced to come to the union office during non-duty time and execute forms that were available only in the union. The authority said that this was too stringent a requirement. It has to be easier for people to exercise their right to withdraw from the union. So if you're a union, just don't make it too difficult for people to withdraw, and then you won't have any trouble with this particular ULP. All right, that's it for me. Thanks so much for listening. I hope that this was informative. The information that I gave on this topic is a start, but it is not comprehensive. If you're interested in learning more about this topic or about other topics involving the statute and the FLRA, I would encourage you to attend one of our in-person trainings. You can see a schedule of our in-person trainings on our website, www.flra.gov. Under the Resources and Training tab. We schedule them periodically all over the country in our different regional offices. Alternatively, if there's enough interest at your agency, you can schedule your own training, and we will come and give you a training in person. We can do it in specific topics that you would like to hear addressed, or we can also give general knowledge trainings on the statute. If you're interested in that, please contact the regional office nearest you, and we can talk about scheduling an in-person training. Finally, there is a Take a Survey button at the end of this presentation. Please take a moment to tell us what you liked, what you didn't like, and what you would like to see more of. Thanks so much for listening.